Okay, let's hear from the applicant.
Good evening. Chris Tarr representing the applicant. To my side.
Chris, could you get closer to the microphone? I can't.
Good evening. So to my right is Tamara Scavir and also Jim Kamalik. If we could all be sworn together.
Certainly. Bruce, do you each swear or affirm to testify truthfully? Maybe just state your name and respond.
James Kamalak, yes.
Tamara Turkevich-Skavir, yes.
Chris Tarr, yes. As was the case with the earlier presentation, we have a slide presentation of several slides. I do, for Mr. Porter, have a copy of those slides. I'm going to bring it up.
Again, this will be Exhibit A1.
So, Mr. Kamalik is a professional engineer, professional planner, has testified before this board in the past. I'll ask him whether he's currently licensed and whether he prepared these engineering drawings. Mr. Kamalik?
Yes, I am currently licensed.
And so why don't you go ahead, and Mr. Kamalik's going to begin the presentation with those engineering drawings so that we can orient you to the site.
Okay, good evening, everyone. I've included on...
Just make sure you can be heard.
Sure. Is that better?
Yeah.
Okay, great.
And again, as in the prior application, if you could put a number on each slide so a record is clear.
Okay.
I've never done. Good evening, everyone. I've included on slide number 2 of the presentation the key map, which indicates the subject property consisting of approximately 2.2 acres, a residential lot fronting on Rolling Mead, which has an existing residential dwelling that is proposed to be subdivided into 2 lots. This key map does illustrate the heavy black line in the central portion of the slide, which is the zone boundary between the R5 zone, which is to the left or to the south, and the R4 zone, which is to the north or to the upper right of your screen. And you'll notice that this particular lot is somewhat unique in that it is located within the R5 zone, where predominance of the remaining Carnessa Park lots are located in the R4 zone. So you can also reference the approximate sizes and scale of the lots surrounding the subject property in terms of the relative size, as there are a significant amount of smaller lots in this particular neighborhood. Slide 3 is entitled Aerial Map, and this is a aerial photograph of the subject property on Rolling Mead. It does illustrate the location of the existing dwelling in the upper right-hand portion of the lot, and it also gives you a sense of the surrounding neighborhood and the location of those residential dwellings within their respective lot lines. And if you look around in a 360 degree view around the lot, you can see that there are several lots in the area, some a little bit larger to the top of the screen in the R4 district, but then as you look down on the bottom of the screen, you can see somewhat narrow lots where the dwellings are located in the center of those lots, but in close proximity to the adjacent property lines. This application is a minor subdivision on the plans before you, which you have hard copies of. Just to summarize, the lot will be subdivided, is proposed to be subdivided into 2 lots. The lot on the right that would house the and continue to maintain the existing dwelling at 1.26 acres. and the lot on the left at 1.0 acres, basically divided somewhat in the center, following what is a natural dividing line of vegetation and trees in the central portion of the lot, which is reasonable and appropriate. To summarize the context of the minor subdivision, again, this is a single-family residential use, which is an approved use in the zone. That will be maintained. The zoning is the R5 residential zone, where the minimum lot size is 1/2 acre or 0.5 acres. In this particular case, the minor subdivision proposes 2 lots, one at 1.26 acres and a second at 1.0 acres. And as you can see, each of these lot sizes are 2 times greater than the minimum lot size allowed in the zone. So it's certainly these lots do exceed the minimum requirement substantially, while still being in keeping with the lot sizes of the surrounding lots in both the R4 and R5 zone. We'd like to iterate that the minor subdivision is fully conforming in all respects with respect to the zoning requirements in the ordinance. And the only reason that we're here tonight, maybe other related issues to this application, which normally would be approved by the subdivision committee, as common on other minor subdivision projects. Lastly, we'd like to say that the proposed lot areas are indeed greater than many of the lots in terms of lot area in the immediate R5 neighborhood, and well exceed the minimum lot area of 3/4 of an acre in the adjacent R4 zone, which is to the north and to the right, pursuant to the previous slide. And therefore, we conclude that these particular lots are very consistent with the neighborhood and the varying sizes within the neighborhood. Again, that slide that you can reference here.
6.
Which is slide 6, with the subdivision line highlighted on the subject property, and you can compare the relative lot sizes, ultimately being in keeping with both of these neighborhoods here. As supporting information for the fully compliant minor subdivision, slide number 7 illustrates that it complies with all zoning requirements pursuant to the ordinance, and that is also indicated on the plans previously submitted. In terms of the staff review memos regarding this project, we've included on slide 8, I believe, the May 23rd review letter by Mr. West and Mr. Bridger. I'll go to slide 9 and highlight some of the comments and the applicant's compliance with those comments. Item number 1, that the new lot will be required to comply with the municipal stormwater management requirements. That will certainly be complied with at the time of plot plan submission for any new building on the new lot. As standard practice, property corners will be located for the new lots. The addresses here have been indicated as 107 and the remaining dwelling 109 Rolling Mead. That will be reflected on the revised plans, as well as meets and bounds descriptions for the final lots to be submitted for municipal review, and the horizontal and vertical coordinates for the survey map as item number 5. A tree removal permit will be submitted at the time of any disturbance on the lot or tree removal on the property, which is item number 6, that will be complied with, as well as providing a tree location plan indicating the trees that would be removed as part of any construction, and replacement trees as well to comply with the ordinance requirements. All utilities will be installed underground, and any required outside agency approvals pursuant to item number 9, Sewer Operating Committee, Mercer County Planning Board, which has already been approved. Sewer Operating Committee we have already received their approval. And given the conditions of the property and regulated wetland features along the rear property line, connection to the municipal storm system, which is also at the rear property line, will necessitate an approval from NJDEP in order to facilitate that sanitary line connection. A road opening permit will be applied for at the time of construction. The revised plans will include the 2 additional street trees that were requested, as well as the conservation easement that addresses the regulated environmental areas at the back relative to the existing wetland area and transition areas. The driveway will be located more than 5 feet from the property line. The survey adjustment will be made for the 100th of a foot digit, and the existing asphalt driveway apron will be replaced, and we will note that on the revised compliance plan to be reviewed by staff. So in summary, all of the staff recommendations and requests the applicant will comply with pursuant to any approval by the board.
My name is Tamara Turkevich-Skavir, and I live at 109 Rolling Mead. I was barely 6 when my family, the Turkeviches, moved into its newly built ranch house at 109 Rolling Mead. In front of our house, Rolling Mead was a dirt road. In fact, both North Littlebrook and the Littlebrook roads, dead-end streets, were dirt roads. In time, the roads were paved, houses, Cape Cod's ranches, split levels, were erected, and Littlebrook School, with its playground, arrived. As a kid, I loved wandering through the extensive fields all the way up to Snowden Lane and following the brook to Overbrook Circle. There were very few trees. My parents had hoped to retire in our ranch house, but had not foreseen that maintaining such a large parcel of property would be as physically and financially draining on them. They decided that it would be wiser to move, and we inherited Rolling Mead in the early 80s. My father encouraged us to keep the field mown so it not be an eyesore for the neighborhood, and so the lone apple tree might be enjoyed. This we have done. He also forewarned us that if we ever considered subdividing the property, we need to understand the covenant which came with the property and to proceed with good common sense and good legal counsel. So from 1982, my family, now the Skavirs, has enjoyed living at 109 Rolling Mead. Our daughters, as I did, played Frisbee and lacrosse on the field. My husband and our daughters, as I had many years earlier, saw the community around them change, evolve. First, it was the fine house and property across the street. The house doubled in size. A large barn appeared in the woods. Then many other houses were transformed into beautiful new dwellings. Less than a handful of the original homes from 1950 remain unchanged in the Carnassa Park community. It is very different from the original neighborhood I knew, but just as beautiful. By 2013, both my husband and I had retired from teaching. It was time to consider options for our future. We decided we wanted to remain in our ranch house. However, to do so, we would need to subdivide and sell the field. Otherwise, it would be a burden to us, as it was to my parents. We are blessed with good health and have had the time to proceed through all the necessary steps to do this correctly and legally. Our hope is to keep the feel of the neighborhood by having only one home on the 1-acre field and to remain at 109 Rolling Mead. We are long-standing members of the Princeton community. We are not developers, and we look forward to our future here, preferably on 109 Rolling Mead. Thank you.
Thank you, Tassi. Next slide. There were two views of the house, and do you keep numbering the slides for us?
13.
Yeah. There were two legal issues I wanted to mention to you before we let others speak. The Scaviers and Dr. Turkevich before them allowed the neighborhood children to come up the hill and use the folks on Locust Lane to come up and on the way to the schools. Littlebrook School is just to the top of the slide. And they just walked across the open field, which is on the drawing as you see it here, just on the left-hand side of that drawing. In 2010, Bob Kaiser, our municipal engineer, approached the Scaviers and said, you know, we really would like, as the town, we'd like to formalize this arrangement. You don't have insurance and people are walking on your yard, and we don't have any comfort that this relationship would continue. So on the next slide shows that relationship of Locust Lane, just so you understand. The Route 227 is down at the bottom. Locust Lane is a cul-de-sac. There's no sidewalk on Roper Road all the way over to the side of the slide, so it was much safer for the children to just go down to the end of the cul-de-sac on Locust and go through the Scaviers' yard to get up to Littlebrook. And that's what they did.
Mr. Tar, maybe if you went back to slide 6, that would show up better.
Yes.
Right?
The key map.
Yeah. The key map, this one. Yeah. They go, the folks who live on Locust, many of whom are sitting behind me over on this side as a group, very anxious to make sure that this arrangement continues. We're here to tell you we'd be happy to have it continue. And so this is what this legal issue we're going to talk about. If we could go to the slide, please, that has the document. And this is number
15.
So this is a license agreement which was executed in November of 2010 between the township and the Scaviers, which talks about providing pedestrian access across their property for school children attending the Littlebrook School. And so it's a formal legal document that exists. It's called a license because it could be revoked if it was abused, the sense being that there's every intention to keep it in place. But if the children were misbehaving in the woods or some other circumstance occurred there, or people were riding dirt bikes or whatever might occur, the property owner felt that they needed to be able to talk to the township and cut out that behavior. So it's characterized as a license agreement, but it's the intention of the owners to keep it in place. And I'd like to go back to that slide that showed this is the proposed location of that pathway is in green. In other words, right up the line between the two lots, meandering to avoid existing trees, but to form a relatively straight line up to Littlebrook Road, to Rolling Mead and then on to Littlebrook. It's crossing through some DEP-regulated areas, and there's a bit of a concern that if the DEP were to object, then it's proposed that the pathway go to the left, the red line that would go up through an area that's less subject to the DEP areas. So the proposal is to mark it as being between the two lots, where the green line is, only if there's an objection raised by the government, then it would go up where the red line is. But the license would remain in place and be modified only in the sense of the location of the path. So that's the first legal issue. There's a pathway that some of the neighbors are very anxious to have and that the Scaviers are anxious to keep in place. Second and last issue has to do with these private restrictive covenants. So you had a,
16.
this is slide 16. It's just the cover of the Cox textbook that you all know. And he speaks to this issue that you discussed as you started off, the relationship, or more accurately, the absence of a relationship between private covenants and public zoning and planning. So within his text, there's just some language which I've highlighted on the issue of restrictive covenants in deeds. And it reads, quote, "Sometimes a board may have before it a case in which a tract of land is subject to the terms of a restrictive covenant in the deed." I've skipped over some of the words, but I've given you the essence of that sentence. And down below it says, "Such a covenant in no way affects the jurisdiction of the board to grant a variance." The next sentence reads, "The grant of a variance in no way affects the validity of the covenant, nor the covenant the validity of the grant." And finally it says, "From the standpoint of the board, the existence of such a covenant is not a basis for denial." And it cites Davidson Brothers and some other cases. Again, for old Princeton files, the Davidson supermarket was on Nassau Street. This was their store in New Brunswick, that they had a restrictive covenant against other grocery stores, and the court said that it had no bearing on zoning. So Mr. Cox tells us that they are not related in any way, and this is how we've proceeded in coming before you. So I hesitate to talk about the private restriction, but I thought you'd just be interested, Mr. Cohen having a private restriction on his land and knowing that there's an issue here. We're not crazy. We're not coming in here ignoring that private restriction. And let me explain. Next slide is a deed from 1961. Mr. and Mrs. Johnston lived in Carnessa Park, and it's a deed signed by two-thirds of their Carnessa Park neighbors, indicating the neighbors' consent to the Johnstons subdividing their lot. They got municipal approval, they had this private approval, and they went about subdividing their lot. It was subdivided. The next slide is a document called a release of restriction, which we've worked on. I want to tell you, I started working with Dr. Turkevich in 1973 on this issue, and he was hell-bent, if I may say, to cause this to happen. He was one of the original Carnessa Park owners and occupants, the creators of Carnessa Park. He knew that there was a restriction against subdivision which would require, as we read it, two-thirds of the other owners to sign the document. We've listed here and on the next slide the 31 owners who signed, had the notarized signatures on the document agreeing that in this case and in this case only, it was acceptable to those folks to have this lot subdivided for the Turkevich-Scavier family, which has lived there since the very beginning. And we're prepared to deal with that issue, but as Mr. Cox said, it's unrelated to what you're doing. And I know that you're going to hear tonight from folks who feel that they are related or that there's some issue that should come before you. You've got to deal with that as you choose. But it is our view that we've dealt with it, and we've dealt with it effectively, and we just want this conforming. It's 2 times conforming. The zoning's half acre, the smallest lot is 1 acre. It's so substantially conforming that within your purview, where the staff has said everything's fine, we agree with all their suggestions, and it's conforming. So that's where we are. I'd hope that we could limit the comments to the subdivision that you're doing and any objections there are to it. But with that, we ask that the public be heard.
Can I ask a question about that? Are there examples of a board denying an application based on the covenants and then it's being challenged?
I think that's what Davidson was about. The Davidson supermarket said you can't have another supermarket here, and the court said, well, that's not the board's affair. And that's what, let's go back to that yellow.
But I thought that the zoning board approved it, but the covenants prevented it.
Well, what Mr. Cox says, whatever the facts were in any given case, that last sentence, from the standpoint of the board, the existence of such a covenant is not a basis for denial. So that's where we are tonight. We're asking you to approve. And the existence of a private covenant is not a basis for denial.
Yes. Mr. Torrey, could you go back to the slide that showed the signatures on the subdivision? One of the last, that one. When was that signed?
Yeah. So when?
When were they
Last
signed?
year.
Yeah, I'm trying to remember that because
It was
Not
last year.
last year?
Yeah.
Right.
Then we filed here, and it takes a year to be
Right.
heard. So.
Okay.
Any other questions? All right.
You know, just to clarify the record, I'm confused as to the purpose of the applicant's release of restrictions that you've submitted here. You're not asking the board to verify anything. Are they irrelevant to your application here?
Absolutely irrelevant. But I thought that somebody made the comment, you'd be crazy to just fly in the face of restrictions. I should mention there's one other case that occurred in 1964 in Carnessa Park. After the 1961, Mr. Peterson subdivided his land, and a builder just came in and he just didn't ask anybody anything. He just subdivided his lot, and a lawsuit was brought against him. You just can't unilaterally subdivide your land, and that fellow was precluded from doing it. But the model that we're following is the Peterson in 1961, who got the signatures. There are 45 lot owners. You need 2/3, and so that's what he did. That's what we did. And I'd bring it to your attention just if there's an anxiety. This is a tough legal question. It's not something you see all the time. It is utterly irrelevant according to Mr. Cox. And I brought it up reluctantly, but because you're going to hear about it, and I didn't want you to be confused any more than I could help.
Do you have copies of this for?
That's here.
I mean, you don't have
Yeah.
copies that we could look at.
It's irrelevant in technical terms. I just wanted you to know that 30...
No, I know.
So that's where we are. We did it reluctantly. It has
Is that
nothing...
list? When is that list? What year was that?
Last year.
Last year?
Yeah.
Okay. All right. Sorry? Yeah, let me just ask Alan Porter about this list, because I'm still a little bit confused. I would have thought that this was a group that made decisions rather than individually signing off on each thing. Is that?
Well, I think let me respond. I think there are two issues here. There is, within the restrictions, as I understand it, the ability for two-thirds or whatever the number is to approve of something that's otherwise not permitted. And as I understand it, you're in the process of submitting this to Carnassa Park as satisfying the requirements for subdivision?
We met with the board. We're going to record it with the county clerk. It's, it's the process.
But for our purposes, can we view this as void and no purpose for our subdivision? I mean, otherwise the board is going to
I would view it
be...
as irrelevant, and I
Okay.
apologize if you took it in any other way. You will hear, I could have brought it up an hour from now and say, they're wrong, we're right. I just thought you'd want to understand.
Is the board going to be hearing testimony as to people who signed this and didn't understand what they signed or want to withdraw their... Because
right.
I'm going
And
to
that-
tell
and
the
that-
board that
right.
that's really not the issue
All right.
before it.
Well, I understand, and so if that's, as has been discussed among you, if it comes to that, that will be the subject of private litigation, nothing to do with what you're deciding according to Mr. Cox. I brought it to your attention just to indicate that there were restrictions which exist. We've dealt with them in a way that we think is legal and proper, and all that you have before you is the drawing that you see on the screen, where the lots are twice the size that they're supposed to be.
All right, why don't we open the meeting to the public, and I'm going to ask you to come forward, be sworn in,